Thank you. Good morning, and thank you all for coming to this organizational meeting of the Committee on Ways and Means Subcommittee on Social Security and for the 115th Congress. I'd like to start by introducing the members on my side of the aisle. And I'm not sure they're all here, but on the committee are Mr. Rice of South Carolina, Mr. Schweikert of Arizona, Mr. Buchanan of Florida, Mr. Kelly of Pennsylvania, Mr. Renacci of Ohio, and Ms. Wolarski of Indiana. At this time, I now recognize the ranking member, John Larson, for purposes of introducing him, members on his side.
Well, I thank you, Mr. Chairman, and want to say what an extraordinary honor this is to serve with you on this committee. As I've said many times in the committee of the whole here, that to be able to sit between Sam Johnson and John Lewis is an experience that people will talk about all of their lives. Two incredible Americans who epitomized the definition of patriotism, and to know their remarkable records long before they got to Congress in terms of what they endured on behalf of the nation they love and are sworn to serve is nothing short of remarkable. And I know I speak for all the members of, on both sides of the aisle, of their remarkable service. I would like to introduce the members that serve, and as John, are you going to introduce the members on the on your committee as well, the subcommittee? But serving with us on the subcommittee on Social Security on the Democratic side are Bill Pascrell of New Jersey, Joe Crowley of New York, and Brian Higgins, also of New York.
Thank you. I now recognize the ranking member to introduce the staff on your side.
Well, again, I thank the chairman, and we don't give staff the recognition that they richly deserve for all the work that goes on while we're gone and while we're here and into the night. But I want to thank both Catherine Olson and Surat Adapit, who are both here and serve on the Democratic side, as well as Scott Stefano and Sylvia Lee, who serve on my staff as well.
Thank you. The staff director on the Republican side is Amy Short. You can stand up if you want to. We also have Social Security Counsel Sean Freeman, professional staff member Laura Rossner, and legislative assistant Matt Russell. During the 115th Congress, the subcommittee will make sure the Social Security Administration is providing the service Americans expect and deserve. Did you want to make a statement?
No, not.
The Social Security number is an important part of our jurisdiction, and we will build on past efforts to make sure American identities are safeguarded. We will also continue much-needed conversations on Social Security's solvency, as it's our responsibility to ensure that our children and grandchildren can count on this program, just like seniors and individuals with disabilities do today. I know it's a concern that our ranking member shares, and I look forward to working with him and all my colleagues. At this time, I recognize the ranking member Larson for any additional comments he may have.
Well, I thank the chairman, and I thank all the members of the respective committee. I recognize that we're sitting here in joint subcommittee this morning, but and I'm so heartened by our dialogue and conversation leading up to this meeting. Congress is where the vitality of ideas can compete, where we can dialogue, debate, have inquiry, and yes, even compromise. This can and should take place in the regular order of business. I am heartened in my discussions because both the chairman and I think everyone on this committee, share a vision about securing Social Security into the future, and I thank him for being willing to have a hearing on a bill that I proposed, and I know he has a bill himself that I think lay out a competing vision for where we would like to be with regard to Social Security. Now, I know a little bit about insurance, having come from Hartford, Connecticut, the insurance capital of the world, and I believe this committee has an opportunity, amidst all the uncertainty that's taking place with respect to the Affordable Care Act, with proposals to block grant Medicaid, with issues surrounding Medicare. But this committee has an opportunity to bring clarity and certainty to people's lives that the Social Security insurance that they have paid for provides. There is nowhere in the private sector that you can purchase a policy that has survivor's benefits, a disability benefit, life insurance, with a cost of living adjustment built into the pension that they receive. Simply put, it's the most essential program that citizens have paid premiums into an insurance contract that is backed by the full faith and credit of the United States government. I want to commend President Trump. I want to commend him both first for, in the midst of a very heated Republican primary for president, stood singularly alone on the stage and said that no, he would not cut benefits to Social Security, that in fact he would preserve Social Security. And even after his election to president, recognizing that this is the bedrock program for the nation. For a third of the country, as all of the members I know realize, that this is the only retirement program that they have. And equally important, for over 2/3 of the people in this country on Social Security, Social Security will be half or more of all of their retirement funds. That's an incredible statement. And again, underscores, I think, the president's desire to preserve and our desire not only to preserve, but expand as we face the growing number of baby boomers who are coming through our process. We owe it to our citizens as stewards of their insurance program to ensure its actuarial soundness and the promise that has been explicit since its inception, that Social Security will never miss a payment, and it will be there for them in future generations. I thank the chairman.
You're welcome. You know, during the 115th Congress, the subcommittee will make sure the Social Security Administration is providing the service Americans expect and deserve. The Social Security number is an important part of our jurisdiction, and we will build on past efforts to make sure Americans' identities are safeguarded. We will also continue much-needed conversations on Social Security's solvency, as it's our responsibility to ensure that our children and grandchildren can count on the program, just like seniors and individuals with disabilities do today. I know it's a concern of our ranking member as well, and I look forward to working with him and all my colleagues. Finally, a couple of housekeeping items. As in years past, the subcommittee will operate under the same rules as the full committee at hearings. The chairman and ranking member or their designees will each make an opening statement before we hear from witnesses. Other members may submit written statements for the record. The chair intends to require both witnesses and members to adhere to the 5-minute rule for testimony and questioning. With that, this organizational meeting of the Committee on Ways and Means Subcommittee of Social Security will stand adjourned. Now, I just want to say good morning and welcome to the first of our two joint Social Security and oversight hearings on Social Security's representative pay program. In 1939, Congress first authorized Social Security to make benefit payments to another person or organization when it was in the best interests of the beneficiary. The last time Congress made changes to representative pay programs was in 2004 through the Social Security Protection Act. This law increased the oversight of representative payees. I believe it's now time to take a fresh look. This two-part hearing series seeks to answer the following questions. Is Social Security's representative pay program working the way it should? How is Social Security improving the program to meet today's challenges? And are there changes we should make to ensure that Social Security provides the services Americans expect and deserve? The Social Security Administration will be here for both hearings, helping us to understand the agency's management of the representative pay program, including the challenges it faces. After the two hearings, I want Social Security to send us a report that covers, 1, the challenges facing the agency, 2, the improvements Social Security will make, and 3, what legislative changes Social Security needs, in their opinion. We all need to work together to make sure the representative pay program meets today's challenges. It's too important not to get it right. Today's hearing will focus on those who need help and the process Social Security uses to identify them. About 9% of those receiving Social Security benefits get help from a representative payee to manage their benefits. That may not sound like a lot, but with a program of Social Security's size, it means about 5.5 million people have a representative payee. And this doesn't include those receiving supplemental security income, who also have a representative payee. Many folks have a representative payee. For example, children receiving benefits must have a representative payee, as do those who have been declared legally incompetent by a court. But others may need help as well. They or a loved one may tell Social Security they need help, or a Social Security employee may notice that the individual could use help managing their benefits. In this case, Social Security conducts what's called a capability determination to see if the person needs a representative payee. Social Security's field offices employees make this decision by reviewing lay evidence and medical evidence. While medical evidence is part of the process, lay evidence is meant to be the deciding factor. Lay evidence is anything other than legal or medical evidence that provides information about whether someone can manage their money. This could be a statement from a family member, a friend, or someone else who knows the person well. Deciding who needs help managing benefits is an important responsibility, and Social Security has to get it right. However, as we will hear today, the Institute of Medicine, the Social Security Inspector General, and Social Security itself may have all raised some serious questions about how the representative pay program works. Of serious concern is that Social Security employees routinely fail to follow Social Security's instructions for completing a capability determination. According to a June 2015 Social Security study, more than 70% of cases reviewed did not have a documented capability determination, and over 40% of the cases were missing lay evidence, even though lay evidence is required, theoretically. It's hard to be sure if decisions that are being made are the right ones when evidence is missing. Social Security also does not have a way to see if someone's ability to manage their benefits has changed over time. Just because someone doesn't need a representative payee when they first claim benefits doesn't mean they won't need help 20 years down the road. But unless the person comes to Social Security and says, quote, "I now need help," unquote, it's hard for them to figure it out. Today, we will hear about what Social Security is doing to move in the right direction. We can all agree that the American people deserve better, and Social Security must take this responsibility seriously. I look forward to hearing from our witnesses, and I thank them for being here today, all of you. I now recognize Mr. Larson for his opening statement.
Thank you, Mr. Chairman. I am pleased that we are having this two-part hearing series on the representative payee program at Social Security's administration. Representative payees serve the most vulnerable of the Social Security Administration's 66 million beneficiaries, over 4 million minor children, and almost 4 million adults with physical or mental impairments that are so severe they cannot manage their own benefits. This includes seniors with dementia and disabled adults with severe mental illness or significant intellectual disabilities. And while it is an important focus on the payee program, I would like to address last week's vote on the House floor that was related to this issue and exemplified what's bad about the process and speaks to why so many members on our side are frustrated. Last week, we voted on a Congressional Review Act, a resolution that eliminated a process for SSA to report to the National Gun Safety Background Check System the names of individuals who are not eligible to buy firearms because of a severe mental incapacity. That is a requirement of existing law. Individuals with severe mental incapacity are not allowed to own guns. Without even holding a hearing, and I know this is not the work of the chairman, the majority put the cart before the horse and used a fast-track procedural tactic to weaken the background check system that protects Americans from having firearms which may fall into the wrong hands. We have a serious gun violence problem in this country, but we can't even get a vote on common sense measures to prevent gun violence. That is particularly why our side of the aisle is frustrated. It is why last year in June, we took to the floor out of frustration that we are not even allowed to have a vote. We recognize that the majority controls the floor and has the ability to defeat any legislation that we might put forward. And so it's even more, the frustration is compounded when we don't even get an opportunity to express our views and have an up or down vote on them, knowing full well that in fact we may not prevail. And so we felt very strongly, and it's why our concern persists on the floor of the House, that we need to have a vote on issues that are as important as this. It was most troubling last week, and I'll be honest with all the members on the committee here, I know that you share the same concerns. I know that. But to pit the disability community against victims of gun violence doesn't get to the solutions that I know this committee and the Congress as a whole is after. We need to demonstrate to the American people, especially in the government program that they respect, admire, and count on the most. It is the most essential government program to all of our citizenry, that we get it right. Passing this resolution, I think, set us back and will prevent SAA and potentially all other federal agencies from improving reporting to the NICS background check system in the future. That is why I'm so pleased that Lindsay Nichols from the Americans for Responsible Solutions, the organization that former Congresswoman Gabby Giffords founded, is here today. We asked ARS to testify today to set the record straight about why that reporting was necessary and how it would have protected Americans while respecting due process rights. I appreciate her coming today. I appreciate all three witnesses who are here today and look forward to hearing your testimony as well. SAA appoints a representative payee to ensure that benefits are used to care for beneficiaries. Because these are the most vulnerable of all SAA beneficiaries, it's critically important that SAA gets it right. We understand that SAA has seen 10 million person increase in beneficiaries due to the baby boomers that are coming through the system. Yet since 2010, its operating budget has been reduced by 10% adjusted for inflation. Because of funding cuts, the average wait time for disability appeal is now 545 days. That's simply unacceptable. We cannot have any of our citizens wait that long. There clearly is a need to monitor payees to make sure benefits are being used for the care of the recipients. If there is a problem, SAA needs to be able to change the payee. SAA's monitoring of payees is especially sensitive because there has been some horrific cases of abuses, and I commend the chairman and this committee to making sure that we're always looking at any offense to the nation's top program. Any person who violates the Social Security law through fraud, abuse, or whatever needs to be punished, and punished directly for the harm they are inflicting on all of American citizens. So I look forward to working bipartisanly with the chairman and bicamerally, as we hope we can do, to solve these many problems that we have. Thank you so much.
Okay, thank you. You know, as is customary, any member is welcome to submit a statement for the hearing record, but before we move on, I want to recognize Chairman Buchanan, who has an opening statement as well.
Thank you, Mr. Chairman. I want to also thank our witnesses for their time today. The Social Security Administration was created, as we know, in 1935 with a special emphasis on supporting those considered to be of old age. More than 80 years later, the programs administered by an agency remains vital important to our seniors and people with disabilities. I represent the Sarasota region, Florida's 16th Congressional District, where we have nearly 224,000 people on Social Security out of 700,000. So it's probably one of the top 2 or 3 in the state. Many of the people across the country rely on Social Security Administration every day. It's imperative that the agency functions with care and efficiency, and I think it does in general, definitely, but this is an area I think we can make some improvements on ideally. This is particularly true of the Representative Payee Program. As was outlined by Chairman Johnson, the Representative Payee Program was designed to provide assistance to beneficiaries who need help managing their finances. However, the program faces challenges, not the least of which is the subject of today's hearing, how to determine which beneficiary needs help. With more than 8 million beneficiaries enrolled in the program already, clearly the agency has been successful in identifying some of the beneficiaries who need assistance. Yet research shows that only 9% of eligible people with dementia have a representative payee. That means 91% do not. While not all may ultimately need a payee, there are real questions about how the agency identifies individuals who are at the higher risk of needing help in managing their finances. And further, once a beneficiary has been identified as a possible needing support, what kind of evidence is the agency considering, and what procedure is the agency undertaking to be certain that the best, most accurate determination is being made? Those challenges are unfortunately visible in my home state of Florida. In 2008, just north of my district, in Polk County, a court determined that a 76-year-old elderly adult needed a guardian. In 2013, the woman's daughter, and a court appointed a guardian, and the daughter was from out of state, and a court appointed guardian pled guilty to stealing more than $40,000 from her mother, who was an elderly adult with a disability. Exploiting an elderly person or a person with a disability is a second-degree felony. The woman was sentenced to 120 days in jail and 3 years of probation. She is also forced to repay tens of thousands of dollars that she stole from her mother. While some might call this justice, I find myself wondering what could have been done to prevent this abuse. Is there some way that the exploitation of this senior citizen could have been stopped sooner? Or better yet, not even happened in the first place? Now, I cannot be certain that the elderly woman in Polk County was receiving Social Security benefits based on her age. She absolutely would have been eligible. If so, the Social Security Administration aware that a judge had deemed this individually totally incapacitated. Was the representative payee appointed for the woman? Was the exploitation assigned as a representative payee? These are questions I do not know the answer to, but what I do know is that for 4 years is too long for an elderly woman with a disability to be financially exploited. Whether it's the Social Security Administration or the state guardianship program, someone should have intervened much sooner. As a subcommittee chairman for oversight, I believe it's our responsibility to stay focused. While I am encouraged by the testimony and reports I've reviewed showing that Social Security Administration is taking some steps to strengthen the payee program, challenges continue to confront the agency, and we must make sure that we're doing everything we can to find solution. I look forward to listening to our witnesses today and learning how we can improve the Social Security program to benefit all seniors, especially with people with disabilities. I yield back, Mr. Chairman.
Thank you for your comments, and I'd now like to recognize Mr. Lewis, the ranking member, for any statement he wishes to make.
Well, good morning. Thank you, Mr. Chairman. Thank you for holding today's hearing. I would also like to thank all of the witnesses for being here today. This morning, we are studying the Representative Pay Program. Together, we will learn more about how the Social Security Administration provides a person or organization to handle the benefits or another. This program is a saving grace for seniors struggling with dementia, for the mentally and physically disabled, for children who lost a parent, and for those who lose a spouse. This hearing is an important first step in understanding how we can help the agency better serve the most vulnerable among us. Over the years, many of you have heard me say that Social Security is a sacred trust. It is a trust between the American government and the American people. It is the greatest example of the beloved community in our country. I hope this committee will not shy away from understanding how Republican budget cuts impact this program and other services. These cuts make it harder for the agency to provide the quality service that Americans deserve and expect. I believe in my heart of hearts that the biggest threat to this program is not the retirement of the baby boomers. It is reckless budget cuts. Each and every one of us have a shared duty and obligation to uphold this sacred trust for generations yet unborn. In the regional agency office located in my congressional district, the average waiting time is 619 days to wait for a hearing. Unfortunately, these delays are not limited to disability payment. Can you imagine waiting for almost 2 years? 2 years? America deserves better, much better. Mr. Chairman, we cannot strengthen this program by starving Social Security. Congress must give the hard-working staff the support and resources they need to serve the most vulnerable among us. Together we can do better. We must do better. Again, I thank the witness for being here today. I look forward to your testimony. Thank you, Mr. Chairman, and I yield back.
Thank you. Thank you. Thank you again, and as is customary, any member is welcome to submit a statement for the hearing record. Before we move on to our testimony today, I want to remind our witnesses to please limit your oral statements to 5 minutes. However, without objection, all of the written testimony will be made part of the hearing. We have 4 witnesses today. Seated at the table are Mariana Lacanfora, Acting Deputy Commissioner, Office of Retirement and Disability Policy, Social Security Administration; Dr. Paul Applebaum, Elizabeth K. Dollard, Professor of Psychiatry, Medicine, and Law at Columbia University; Lindsay Nichols, Senior Attorney, the Law Center of Prevent Gun Violence, Americans for Responsible Solutions; and Gail Stallworth Stone, Acting Inspector General, Social Security Administration. Ms. Lacanfora, welcome. Thanks for being here. Please proceed.
Chairman Johnson, Chairman Buchanan, Ranking Member Larson, Ranking Member Lewis, and members of the subcommittees, thank you for inviting me to discuss how the Social Security Administration determines whether a beneficiary is incapable of managing his or her benefit payments. I'm Mariana Lacanfora, Acting Deputy Commissioner for Retirement and Disability Policy at the Social Security Administration. Few government agencies touch as many people as we do. Social Security pays monthly benefits to about 62 million individuals. During fiscal year 2017, we expect to pay more than $940 billion to Social Security beneficiaries. In carrying out these programs, we are exceptionally efficient. Our administrative costs represent about 1.3% of benefit payments under the Social Security and SSI programs. In most cases, we send payments directly to our beneficiaries. We presume that all adults are capable of managing their own benefits, absent evidence to the contrary. However, some of our most vulnerable, including children, need help managing their benefits. We appoint representative payees in those cases. Under our regulations, our field office employees consider 3 types of evidence to make capability determinations: legal evidence, medical evidence, and lay evidence. If there's an allegation that a beneficiary is legally incompetent, we will seek legal evidence. If a court order establishes that the beneficiary is legally incompetent, we will appoint a representative payee. For all others, if there's a question of capability, we will obtain medical evidence as to whether the beneficiary can manage his or her benefits. We also obtain lay evidence, which is anything other than legal or medical evidence that gives us insight into someone's ability to manage his or her benefits. Lay evidence includes employee observations of reasoning ability, statements from the beneficiary, and statements from third parties such as relatives, social workers, and others with direct knowledge of the beneficiary's ability to manage benefits and meet daily needs. If we determine that a payee is needed, the next step is selecting a suitable payee. We examine the representative payee applicant's relationship to the beneficiary, whether the applicant has custody, all known information about the applicant's past performance as a payee, and any criminal history. We also look to see if the applicant has demonstrated concern for the beneficiary's well-being, is knowledgeable about current and foreseeable needs, or lives with the beneficiary. We consistently seek to improve upon our policies. To that end, we asked the National Academy of Medicine to conduct a study on our capability determination policy. Notably, NAM agreed that collecting lay evidence is the most reliable basis for making these determinations. The NAM report also provided 6 recommendations that extend beyond the process for determining capability and also focus on finding ways to respond to changes in capability over time. We have fully implemented one recommendation, and we are evaluating the feasibility of the others. We also acknowledge the work of our Internal Quality Office and our Office of the Inspector General, both of whom have made valuable suggestions for improving our representative payee program. For example, both organizations recommended that we improve controls to ensure our field office employees document capability determinations properly. We are implementing a four-part strategy to address this concern. First, we've comprehensively rewritten our policy to strengthen and clarify guidance on documenting determinations. For example, we added questions for field office employees to ask third parties when they're collecting lay evidence. Second, this April, we will deliver mandatory training throughout the nation through an interactive video broadcast to all of our field office employees who make capability determinations. Third, we are making systems changes to ensure that our employees thoroughly document and explain their decisions using pertinent legal, medical, and lay evidence. And finally, we will continue to measure and evaluate the effects of these changes and make adjustments as needed. Thank you for the opportunity to describe our efforts to strengthen the representative payee program. I'd be happy to answer any questions.
Thank you. I appreciate your testimony. Dr. Applebaum, welcome. Please proceed.
Thank you, Mr. Chairman and members of the subcommittees. I'm Paul Applebaum, Dollard Professor of Psychiatry, Medicine, and Law at Columbia University, and I'm grateful for this opportunity to testify about the work of the committee that I chaired to evaluate the Social Security Administration's capability determination process for adult beneficiaries. Because the work of the committee concluded when the report was issued last March, my testimony is offered as a private citizen and not as a representative of the national academies. The committee was constituted at the request of SSA and charged with providing recommendations to improve the accuracy and efficiency of their procedures for capability determinations for beneficiaries receiving disability benefits. Beneficiaries found incapable by SSA of managing or directing the management of their benefits, as you know, have a representative payee appointed for that purpose. Given the seriousness of the determination of incapability, the committee believed that it should be best based on the clearest evidence available. The committee concluded that real-world financial performance is the most reliable basis for making determinations of beneficiaries' capabilities. Moreover, lay people or professionals who are in regular contact with a beneficiary and able to observe the person's behavior will have better information about real-world performance than a medical professional who sees the person infrequently in a clinic or office setting. In addition, informants need guidance as to how a beneficiary's financial performance should be assessed if they're to provide useful information to SSA's process. Thus, the committee recommended that SSA provide detailed guidance to professional and lay informants regarding the information that the agency would find most helpful for making capability determinations, and ask informants to provide information to indicate the bases for their judgments. Given the concern about SSA's overlooking recipients who may need representative payees, something about which we heard a good deal of testimony, another useful approach that the committee endorsed is the development of a model based on existing SSA data to identify predictors of incapability. Such a model could be tested and iteratively refined with the goal of developing screening criteria that have reasonable accuracy in identifying beneficiaries for whom more detailed assessment of capability is indicated. Another way of improving detection of incapable recipients would be for SSA to exchange data with other federal benefit programs, such as the VA or the Office of Personnel Management, about beneficiaries that each program has already identified as unable to manage their financial affairs, given that some individuals receive benefits from multiple programs. An additional concern is that performance may change over time, given the progressive or fluctuating nature of many psychiatric and neurocognitive conditions. suggesting the value of periodic reassessment of beneficiaries' capabilities. The committee concluded that SSA's lack of a formal process of reexamination is a significant weakness. Some mechanism for periodic reassessment is needed to ensure that such beneficiaries are classified accurately. Given the large number of recipients involved, reassessment might be targeted most efficiently at those beneficiaries whose conditions are most likely to change. In some cases, information about a beneficiary's financial performance will be insufficient to determine the need to appoint a representative payee. In such cases, an innovative approach adapted from a model used by the VA, supervised direct payment, may be helpful. Under such a model, benefits are paid directly to the beneficiary, but an individual is designated to supervise those expenditures. After a trial period during which the beneficiary's use of resources is observed and assessed, their capability can be determined more accurately. The final recommendation of the committee was for the agency to develop and implement an ongoing measurement and evaluation process so that subsequent groups would not get the kinds of responses that we often receive, that data on the functioning of programs was simply unavailable. Thank you for your attention, and I would be pleased to respond to your questions.
Thank you for your testimony. I believe Ms. Nichols, you're welcome. Please proceed.
Good morning, and thank you, Chairman Johnson.
Punch your mic on.
Good morning, and thank you, Chairman Johnson, Chairman Buchanan, Ranking Member Larson, Ranking Member Lewis, and the members of this subcommittee for the opportunity and honor to testify here today. I am Lindsay Nichols, a senior attorney with Americans for Responsible Solutions, the gun violence prevention organization started by former Congresswoman Gabrielle Giffords and her husband, Captain Mark Kelly. The topic of today's hearing, SSA's process of determining capability, relates to the rule that the SSA finalized in December about reporting to the firearm purchaser background check system known as NICS. The House voted to revoke this rule last week, but I appreciate the opportunity to state for the record why this rule is so important. The SSA created this new rule to fulfill its legal obligations under the NICS Improvement Amendment Act of 2007. This rule is simply the procedural implementation of that law, which requires federal agencies to report records of people prohibited from possessing firearms to the background check system. The people who would be reported are already ineligible to possess guns. But without this reporting, records identifying these people are missing from NICS, so these people are able to pass a background check and obtain firearms even though they are legally ineligible. 10 years ago, the nation experienced what happens when records are missing from NICS. At Virginia Tech, a man who was dangerously mentally ill shot and killed 32 people. His records were not in NICS. This tragedy spurred Congress to pass and President George W. Bush to sign the NICS Act, a bipartisan compromise bill. Not only does it require reporting to NICS, but it also requires federal agencies to create programs so that an individual can petition to regain legal eligibility to possess a gun. The SSA's rule fulfills these requirements closely, including detailed and robust due process rights. In order for a person to be reported under this new rule, not only must the SSA have appointed a representative payee, but the SSA must have found that the individual has a mental impairment so severe that the person cannot have any kind of gainful employment. This rule would only apply after the person has received notice. It would not apply to retirees, and it would not apply in cases where an individual simply needs a little help managing their funds. The rule does not permanently remove a person's access to guns. A person who falls within the parameters of the rule can still pass a background check and have guns after a careful evaluation of the person's ability to do so safely as set forth in the rule's relief process. The SSA would not be providing medical information to NICs. DOJ regulations strictly restrict access to the names in NICs, so they can only be used in a background check when a person seeks a gun. The person at the counter at the gun store can only know that the gun sale is denied. So there's no reason to believe this rule would increase the stigmatization or inaccurate stereotyping of people with mental illness. This rule fulfills the law in the books. It is also good policy. While people in this category may not generally pose an increased risk of violence toward others, suicides and unintentional shootings must also be taken into account. Families across America have lost too many lives to gun violence. From Tucson to Orlando. In addition, almost 200,000 people have died in gun suicides in the past decade in the US. An estimated 90% of people who die by suicide had a diagnosable mental illness. Lives can be saved by reducing access to guns when a person's decision-making abilities are impaired by a mental condition. Also, every year more than 500 people are killed in unintentional shootings. Gun owners must have the mental capacity to properly store and handle their weapons. The background check system is only as strong as the records that are in it, and revoking this rule will weaken that system and make our communities less safe. Thank you for the opportunity to testify before this subcommittee.
Thank you for being here. Ms. Stone, welcome. Please proceed.
Thank you. Chairman Johnson, Chairman Buchanan, Ranking Member Larson, Ranking Member Lewis, and members of both subcommittees. Thank you for the invitation to testify today. It is a pleasure to appear before the 115th Congress. As we've heard today, SSA's representative payee program serves a critical need. Some of the most vulnerable Social Security beneficiaries, due to their age or disability, require payees to manage their benefits. The OIG is committed to overseeing how SSA administers the representative payee program. Over the years, our work has shown that SSA could improve the program by strengthening its capability determinations and increasing efforts to identify beneficiaries who may be in need of a payee. The capability determination process begins when SSA learns a beneficiary has an impairment that might affect their ability to manage benefits. When this occurs, the agency must determine whether a payee is necessary. SSA staff are required to record their decision in the agency's electronic systems, noting any relevant medical or lay evidence. We, however, have found examples in which SSA staff did not document the required capability determinations. For instance, we recently identified about 100,000 disabled beneficiaries who had a mental impairment, previously had a representative payee, but now receive direct payments from SSA. We estimated that SSA did not document a capability determination for about 50% of those cases. In fact, that was about 44,000. If these beneficiaries were in fact incapable, SSA should not have paid them directly, particularly because SSA had previously determined that they needed a payee. Similarly, an SSA internal review of capability decisions found that about 71% of beneficiary reviews did not have a documented determination. To ensure that employees document capability reviews, SSA could require a second review and approval for all decisions, or develop systems alert, or better said, systems controls to require employees to record those determinations. The agency recently issued a plan to improve capability determinations. It calls for SSA to remind staff about relevant policies and procedures, to actually streamline those policy instructions, and to enhance the electronic systems to ensure that decisions are documented. Our work has also shown that there are aged and disabled beneficiaries who potentially need a payee, but don't have one. SSA should increase efforts to identify these individuals. In one report, we estimated that more than 200,000 disabled beneficiaries with a mental impairment may have been incapable of actually managing their benefits. We also reported that there were about 5 million beneficiaries over the age of 85, but less than 5% of these individuals had representative payees. SSA could identify beneficiaries potentially in need of payees by 1, analyzing agency data and trends, 2, increasing program awareness through public outreach, and 3, proactively alerting beneficiaries and their family and friends about the program. I also note, as stated by others today, that the Institute of Medicine issued a report on the Representative Payee Program. So did the Social Security Advisory Board, both of them recommending areas of improvement. We agree with both the Advisory Board and the Institute of Medicine that this program serves a vital purpose. My written statement for the record includes additional OIG findings and recommendations for improving the program. To conclude, there are 8 million beneficiaries with representative payees. Thus, the oversight of this program presents a unique challenge for the agency. However, it is critical that SSA explore all options to ensure that it meets the needs of some of our most vulnerable beneficiaries. Thank you again for the invitation to testify. The OIG will continue to work with SSA and these subcommittees to improve this important program. I'll be happy to answer any questions.
Thank you. Ms. Locke-Canfora, in 2013, this subcommittee held a hearing on Social Security's management of representative pay program. The hearing looked at how Social Security decides who needs help managing their benefits. Since this time, what has the agency done to improve the capability determination process?
Thank you for the question. There's been many things that we've done. In fact, we've met with your staffs on a bipartisan basis since 2013, every quarter, to go over the things that we've been working through. I'll mention just a couple that are probably most prominent. One, we talked about the National Academy of Medicine and the report that we commissioned to try to really examine the capability policy and the extent to which it was sound or needed improvement. Based on that report, we have comprehensively rewritten the policy around capability, making it stronger. For example, we've added questions that our field offices can ask to laypersons who provide evidence to ensure that we elicit the right evidence. The other thing we've done, now there's many things, but I'll mention another one that I think is very significant, and I think it'll be the subject of the second hearing, which is we have launched a 5-year on-site monitoring contract that will significantly increase the number of on-site reviews that we conduct of representative payees, and it has also significantly broadened the scope of those reviews.
So you think that Social Security has made improving the capability determination a top priority?
Yes, sir.
Okay, I appreciate that. Dr. Applebaum, as you know, Texas has been a leader in support decision-making. For those that aren't familiar, can you talk about what supported decision-making is and why you think Social Security should try it out?
Yes, certainly. The notion of supported decision-making is that many people with disabilities can, with some assistance, continue to make their own decisions and manage their own affairs. That has the advantage of retaining their autonomous functioning, both in terms of the decisions they make and the actions that they take, and avoiding the necessity of appointing, in this case, a representative payee to oversee their benefits. It also has the advantage, as far as capability determinations are made, of having an independent, objective person who can provide feedback with regard to the person's ability to manage their benefits on their own. So were the model to be implemented in this context, Someone would be appointed as an aide, an assistant, a decision-making assistant support to the person with a disability. The person with the disability would continue to receive their payments directly, but that person would provide assistance and guidance as needed to help them with those decisions. The committee recommended that SSA consider implementing this on a pilot basis to see how well it worked and gain experience with it.
Well, do you think they can do that without adding significantly to Social Security's workload?
Well, currently, some percentage of the people who are being evaluated for and receiving representative payees to manage their benefits would probably do just fine with supported decision-making. Were those people who are being designated as representative payees instead designated as supports for decision-making, you would not need any additional personnel or, frankly, any additional process to accomplish that.
Do you think it's fair to say that some people who are currently being assigned a representative payee might be better served with supported decision-making instead?
Yes, I think that's clear. We don't have any idea of the numbers, but I think in general, yes.
Well, thank you for your testimony, sir. Mr. Larson, you're recognized.
Thank you, Mr. Chairman. And I want to thank all the witnesses. My first question, and Mr. Chairman, is there going to be more than one round of questioning, or is this it?
I think with two committees,
Okay,
you better
one round.
hold to one, don't you?
Yes. So I would ask, my first question would be to Ms. Lancome-Fora, Mr. Applebaum, and Ms. Stone. Ms. Stone, and I thank you all for your work and service. You raised some questions, and one of the things that is disturbing to me, of course, is, as mentioned in my testimony, an increase of more than 10 million people growing and expanding as the baby boomers come through this process. At the same time, we've seen a reduction in the Social Security administrative budget. How does that square up, especially, and Ms. Stone, you mentioned in your testimony a couple of things, making sure that there were system controls and electronic assistance. When is the last time that Social Security was upgraded in terms of its electronic assistance and its computer and technological capability to deal with this issue? That would be my number one concern. And number two, and Mr. Applebaum, you spent an awful lot of time in your testimony talking about the recommendations that you have in some areas, obviously, where there could be potential savings that accrue. How can we best integrate this in a manner in which, as the chairman mentioned, we do not overburden the committee? And I would like your opinion on whether or not, with this influx of 10 million with baby boomers, is this placing an enormous strain on a committee that I'm just going to guess that the administration, just a wild guess on my part, has not been brought up to speed technologically, especially given all of our concerns that we have today about the ability of people to hack into a system. So if you could get that to me in writing, and I would reserve my question. And again, thank Ms. Nichols for being here and our colleague Gabrielle Giffords for the incredible work that they are doing. I said at the outset our alarm on this side of the aisle and frustration of pitting two groups against one another within the context of this payee system, the victims of gun violence and people with disabilities. Ms. Nichols, do you believe that prohibiting the SSA from ever reporting severely mentally incapacitated individuals to the background check system has made our public safety laws stronger or weaker?
Revoking this rule will make our laws weaker, and it will make our communities less safe. I mean, revoking this rule is clearly detrimental to public safety. and is a failure to enforce the laws on the books, namely the Nix Amendment Improvements Act and the Brady Act, and the gun laws in general. It will cost lives in terms of family members who will be at higher risk of suicide, and the increased threat of gun accidents. The American people need to do recognize that need to keep guns out of the hands of severely mentally impaired individuals, and that is what this rule would do.
Well, I don't know if many of our colleagues understand completely the ramifications of a CRA, but because of the nature of what a CRA means, this would prohibit the executive branch, and not only from the standpoint of SAA, but other agencies, from issuing any kind of rules with respect to simple regulations that Nick's reporting had required. Would you agree with that?
Yes, it would prohibit any substantially similar rule in the future.
And this is, again, Mr. Chairman, why on our side of the aisle we are so frustrated and upset that we can neither get a vote on the floor of the House with respect to this issue. Now, before there's an actual hearing on it, there's a vote that not only prevents SAA from ever doing any further regulations on that, but other agencies as well. I think it's an egregious fault of this system, and I hope that we can remedy that through legislation.
Thank you, Mr. Chairman. And I'll now recognize Chairman Buchanan.
Thank you, Mr. Chairman. I want to say, I mentioned being from the Sarasota region, southwestern Florida. I probably have as many as anybody does, 224,000 recipients of Social Security. But in general, I think you guys do an outstanding job. That being said, there's always room for improvement. I think Mr. Larson, I think it was his number, a third of Americans get to be 65, and that's all they got is their Social Security. I also heard another third have something, but not enough. So they're counting on Social Security. Of course, it's their money, so that's a big issue. But let me just lead off with you, Ms. La Canfora. We touched on, maybe you did or someone did, that only 9% of people get a payee representative in terms of, out of 100% in terms of dementia. The other statistic I was reading is that 50% of those that are 85 and older, my wife just went up and got her mother, 97, from Michigan, and bring her down to Florida, but over 50%, so we see a lot of those 85 and olders, have early stages or some stage of dementia. But 9% have any kind of support. Where is that at? What's your thoughts on what we can do? I mean, I just can't imagine 91% with no support. And of course, we got a lot of fraud with phone calls and other things, always trying to figure out a way to get money from seniors, especially in Florida, I'm sure all over the country. But is that alarming? It seems pretty alarming to me.
Thank you for the question. Chairman Johnson asked me previously some of the things that we've done since 2013 to improve the program. One of those things is that we commissioned our Retirement Research Consortium, which is a grantee that works with us, to explore this area. And the number that you cited, the 9%, comes from the Boston College, they're one of our grantees, a research paper that they recently completed where they looked at people with dementia, a subset of people, and they found that only 9% were participating in the REP Payee program. But also very interesting, what they found is that the remainder of the people, the 91%, by and large, while they didn't have a representative payee, they did have family support that they considered to be reliable and supportive. We are now embarking on a second phase of that research, and we're going to dig a little bit deeper to look at the outcomes. What are the differences in outcomes with people who have a payee versus those who don't? And the whole purpose of this is really...
I got a bunch more questions, and we're all kind of limited to 5 minutes, but let me ask you another question. I mentioned about this woman 76, disabled. Her daughter stole $40,000, got convicted. How often has that come up? Is that a bigger issue today than it's been? And I guess, what do you do about it?
We do detect misuse and abuse in the program, although it is a very small percentage. But I will go back to something that was said earlier about the workload impact. I must admit that our greatest challenge is monitoring the representative payee behavior. We have 6 million representative payees, and we currently do 2,000 on-site reviews annually, which you can do the math is not a tremendous number of on-site reviews.
Then let me move over to Ms. Stone. Thank you. And we'll have a chance to visit more on this.
Thank you.
Mrs. Stone, I wanted to get your thoughts as the Inspector General's office. I know you've looked at this payee closely, and I'm sure you identified some challenges or weaknesses. Are they receptive to your thoughts and your ideas in terms of implementation of maybe some things to minimize some of these areas of weakness?
That answer would be yes and no. When we've directed them or pointed them to specific beneficiaries where they should go back and do capability determinations, they've been very responsive, and in many cases either given them a new payee or determined that the people were capable. However, some of our more strategic types of recommendations, such as outreach and the broader concept of identifying a population of people potentially in need, that has not been as receptive.
Thank you, and I yield back, Mr. Chairman.
Thank you. Mr. Lewis, you're recognized.
Thank you, Mr. Chairman. Madam Deputy Commissioner, I'm very concerned about the Republican cuts to your agency operating budget. And we continue to have people waiting for so long, 560 days. Is the less money, cuts in the budget, affecting services?
We have seen an increase in field office wait times, and there certainly is a correlation between our funding and our ability to deliver timely service. Beyond that, I think if you'd like us to give you more information about what work we can do within various budget scenarios, we'd be happy to do that.
But do you think it's fair for people to wait so long a service that we made a commitment?
No, sir.
So are you saying anything to the majority party about what should be done?
Yeah, I think we consistently communicate our budget needs, but we also are trying to focus on efficiency and improvements in our business processes, our IT, and any other place that we can strengthen our process to work within the constraints of the budget and at the same time make our needs known.
But in the meantime, people hurting, people suffering. It's not fair. It's just not fair. It's not right. There's a sacred trust between the people and the government. What should we be doing? What do you want us to do? Appropriate more money?
I didn't hear the answer.
I'm sorry, can you repeat the question?
What should we do? What do you want us to do? I'm trying to imply there's a commitment, there's a sacred trust between the government and the people.
I mean,
We
this,
should not violate their trust.
I agree with that. This committee has been certainly supportive in holding multiple hearings on the topic of representative payee and giving us the support we need to try to create improvements in that process. As I said, there's certainly a correlation between the funding that we get and the services that we deliver, and we have laid out quite extensively our resource needs.
Madam Inspector General, do you have any respond to what is happening?
Sir, I would actually defer to the agency with respect to their resource needs, but I will hearken back to one of my earlier comments in a question about the need for investment in information technology or systems to actually improve this process. I recognize that that is one of the elements of the agency's capability determination plan, and that will be the critical element that should bring about some efficiencies, because that process will help the agency meet the current policy that it has.
Could either you tell me when was the last time that the system was upgraded?
I can speak to that. So I'm happy to say we have done a modernization of our representative payee system. We released that software last year, and we will continue to build upon it. That's a major improvement, one of the things we've accomplished since 2013 in improving the Rep Payee program. We've created a web-based system. It's more agile. We can modify it more easily. And to Ms. Stone's point, we are building in compliance so that technicians will have to document very extensively the capability determinations that they make. So we have, in fact, released that very significant IT modernization software.
So the bottom line is you need more resources. You need more money, less cuts.
Resources are critical to the function of the agency, absolutely.
Thank you. Mr. Chairman, you're back.
Thank you.
Mr. Rice.
Yes.
Thank you,
Rice,
Mr.
you're
Chairman.
recognized.
Thank you, Mr. Chairman. Ms. Wakenfora, this 500-day delay in receiving benefits, when somebody reaches retirement age and applies for their retirement benefit, it takes 500 days for them to get it?
No, there's different types of benefits, and so I think the congressman is referring to specifically disability benefits that are adjudicated before an administrative law judge.
So,
Those are the
we're
decisions.
talking about the time in which you have to figure out whether they're disabled or not.
Correct.
Yeah. Okay. With respect to the scope of this hearing and overseeing people's payments who are disabled, I was a tax lawyer. I did a lot of estate planning. Some of the most wrenching things that I dealt with in families are whether somebody's disabled or not, whether a family member may think they're disabled or incompetent, and the subject may not think that they are. So you have one heck of a tough job. Good grief. You got 6 million people in this category. If somebody makes a claim, well, overall, you're mailing out checks to these retirees, 50 million checks a month. You don't ever meet these people. You don't see them face to face, right? So how could you possibly determine whether they're disabled or not?
Generally speaking, for people who file for retirement benefits, that decision would be made at the point of application. If that person then, goes off and they're 65 at the time that they file, and then they age beyond that, you're right. We have generally very little interaction with individuals, so we do not have a comprehensive process for tracking a person's capability over time. We rely on individuals and their families to
You don't
report
go
to
out
us.
and meet with them and interview them face to face every 2 years or anything like that.
No, sir.
So you got to rely on somebody in the community, whether it be a family member or otherwise, coming to you and say, hey, you got a problem over here, right?
That's right.
Do you have folks in your local agency offices that have any mental health expertise, or are you just using guidelines that you have written for Social Security?
To make the capability determinations themselves, we collect evidence, the medical, legal, and lay evidence, and that's how we make those assessments.
Okay, but they don't have any mental health experience themselves. They're just doing the best they can to make the best assessment they can,
That's
right?
correct.
Now, what happens if you have somebody, a daughter who comes in and says, you're sending checks to my mom and she's buying things I don't like and I think she's disabled, and the mom says, well, no, I'm not disabled. Surely y'all don't make that determination. Surely you require some kind of an adjudication of it, right?
So the assessment of disability is separate from the assessment of capability, right? We have an extensive process for determining disability. We use a state agency adjudicator to examine extensive amounts of medical evidence. That's a separate process. The capability process is one where we're solely trying to determine whether you can manage your funds or direct the management of your funds, and that's an important part.
Yeah,
So
but you're actually taking somebody's property. I mean, this is their property. As a tax lawyer, it always fascinated me that the IRS could come and take money out of people's bank account without a hearing, right? I mean, they're the only government agency I ever thought that could do that until now. Because apparently Social Security can decide, hey, you're not capable of getting your check, even though you might think you are, and route it to somebody else.
It's important to remember that we assume capability in all adults, absent evidence to the contrary.
But the guy making that determination may not have any mental health background at all. I would think you would require some kind of a adjudication of competence. You don't?
Generally speaking, the individuals for whom we appoint a payee, they do have the ability to appeal the decision, both the capability decision and the appointment of a particular payee, and we do have people take advantage of that appeal process, but by and large, we're really only trying to give a person a payee if they absolutely really need the help managing their money. And in the case that you noted, if the mom is able to direct the management of her benefits, like she might not be able to do it herself, but she can get help from others doing it, we would not give her a payee. Okay, so if the person can either manage or direct someone that they trust to manage, that would not warrant the appointment of a payee. It's only in those cases where they truly cannot manage nor direct anyone else to manage their benefits where we would appoint.
You said that this is fascinating. I can't imagine how difficult this job is. You said you had 6 million people that had representative payees, and you review 2,000 annually. So if you appoint a representative payee over the person's objection, and that person misuses the funds, does Social Security have liability for that?
We have the ability to hold the misuser accountable.
But if they don't have the money, can the person who was supposed to get the money, the original claimant, can they sue you because you appointed a payee that stole the money?
We will make the person whole and then attempt to recover the money from the payee who misused the funds.
Thank you. My time's expired.
Thank you. Mr. Schweikert, you're recognized.
Thank you, Mr. Chairman. Being someone from Arizona, a dozen years ago, we had some really heartbreaking experience with a number of fiduciaries. And I know we actually worked on a series of solutions. Some were technology. And Professor, in your testimony, you actually said a couple things that I actually found some enthusiasm for. But one first, our discussion here, if we're all hopefully discussing the same thing, is some of our brothers and sisters out there who are receiving Social Security benefits who something's wrong in making their payments, in covering their obligations. As we heard in testimony, it looks like majority of that population may be having difficulties. A family member or someone they're living with has stepped in, and that seems to be working well. So now we're talking about the population that may not have that type of relationship in their lives. Professor, and when you spoke, you said there might be some ways to identify by looking at payment history. They're missing their utility payment. They missed their water payment. Could you expand on that? And then I'd like to move from there on a technology solution.
So there are potential ways in which models can be constructed to identify people at high risk of being incapable. That could be based in part on data that Social Security already has, age, diagnosis, degree of impairment, et cetera.
Okay, that's an individual model, and then there might be also sort of it's not really a crowdsourced model, but an experience model. Someone 3 times a year misses their utility payment, or...
Right, but then Social Security would need a way of getting that information.
I didn't say it's easy. I'm looking
don't
for...
have now,
I'm trying to come up with an elegant tell system, because obviously, as you hear from both sides, there's a little bit of discomfort of the non-professional, handing someone in just because there's money involved, and whenever there's money involved, there's sometimes incentives that may not be healthy. So if there was some way to have a tell, someone is systematically making missing payments, or on the flip side, being taken advantage of, and this one drives me, breaks my heart, some of the data I see of seniors that get caught in telephone scams and send out money and things where they've been just taken advantage of. In your work with the Academy, was there any discussion that there might be money comes electronically into the account, automatic payment systems? A certain amount of money goes to a caregiver, a certain amount of money automatically goes to pay the utility bill. And does that provide sort of a safety shield of systematizing that?
Yes, it absolutely does. And that was part of what we envisioned when we talked about a supported decision-making model. That is, a person who acts as an advisor to the beneficiary who says, you'd be better off, you'll never miss your utility bill again if you just have it paid directly from your bank account. And similarly with your rent, et cetera, that leaves the residual amount, which would be much smaller, for the person to spend on a discretionary basis, but only after necessities are taken care of. So that would in fact be a way of protecting many such people.
Ms. Lanson-Fora, and how many of us have butchered your name already today?
That's okay.
Trust me, when you have Schweikert, I understand. In all the things you've looked at, has a technology solution, a automated payment solution that probably everyone in this room actually uses in their lives been discussed for this population?
Certainly, we haven't closed the door on any of the Institute recommendations, and we continue to look at them. We do have a profiling model, if you will, a technology model that identifies those payees who are at risk of misusing benefits, and that's how we select payees to review. We haven't quite figured out how you might determine those who are at risk for a capability assessment.
And I need to think that through, because the reality, they are sort of two completely data sets. As the professor, this is my attributes. You're a certain age, you've had certain types of history that we know, but this one would be almost immediate in saying, for some reason, the copay at a doctor's visit aren't being paid. And I wish there was, I need to think this through, because there's got to be some way to see that. Ms. Stone, in our last 10 seconds, when you were looking at this, did you ever sort of determine saying, okay, we have 6 million within this sort of fiduciary assistance model, how many are actually going unserved? Was there any guess there?
We did look at a very specific population of individuals over the age of 85. Again, that is a very unique population. And in looking at that, we estimated that there are probably about a million people out there that really need to have their capability reassessed.
Okay, so we have 6 now. You think there may be an additional million, or?
An additional, because these individuals did not have a payee at that time.
All right, Mr. Chairman, thank you. And to Ms. Nichols, if there's ever a chance to sit down with you and buy you a coffee, now's not the time and place, but there's a handful of things I'd love to share with you as ideas, and where I think there's some intellectual inconsistency on the issue, and I'd love to see if we could ever close that gap. Mr. Chairman, yield back. Thank you.
Thank you. Mr. Pascrell, you're
Yeah, thanks, Mr. Chairman. This is enlightening today. Now, let me get this straight. Ms. Lockenfora, let me get this straight. So the SSA evaluates the capability of an individual, mental capacity, et cetera, et cetera. The SSA evaluates whether there is a mental disorder. And you mentioned before some improvements to the entire system, which have taken place. So, on the other hand, if you're found incapable, mentally incapable, you still can buy a gun. Is that correct? If you're found mentally incapable to handle your Social Security business because of X reasons, which you pointed out in your testimony, you can still buy a gun.
The capability determination that we make only affects the receipt of Social Security benefits, no other aspect of one's life.
Okay, thank you, thank you. So, Mr. Chairman, in light of the House voting on HJ Resolution 40 last week, which would overturn the Social Security Administration rule that would allow Social Security to report a small subset of individuals with the most severe mental impairments to the National Instant Criminal Background Check System, or to the NICS, as it's called, the NICS. Although it would have been nice to have a hearing before the House, as some have mentioned, we actually did vote on the bill. That's not a good start. That's not a good start. You talk about how additional regulation or oversight of gun purchases will not reduce gun violence because you claim that our gun laws are not the problem. People, you know, that saying we've had for 40 years on our mind, which hasn't solved a damn thing. People kill people, not guns. You know, that's really helpful. While I strongly disagree with the first claim, I agree with the second, which is why I can't for the life of me figure out why some of my colleagues voted to strike down this common sense rule issued by the Social Security Administration. The Social Security regulation resulted from a law passed unanimously by the Congress, you referred to it before, in 2007 in response to the mass shooting at Virginia Tech, where the shooter's mental health prohibitor should have been reported to the NICS, but was not reported. You heard Ms. Nichols talk about that. We cannot state enough that mental illness is not a definitive predator of violence. It is not. But if an individual is suffering from very severe and long-term mental disorder, and his or her lack of mental capacity precludes them from being able to manage their own Social Security benefits, I don't think, you know, correct me, I don't think it's unreasonable to think that they should be flagged for the NICS database. I just don't understand that. Do you understand that, Ms. Nicholas?
Not entirely, no.
They should also be awarded adequate due process rights to appeal this determination, which your regulation allows for. So improving NICS should be part of a balanced approach where Democrats and Republicans work together to find solutions that protect Second Amendment rights while keeping guns out of the hands of those who would use them for harm. You will not allow that person who is ruled incapable to judge his own Social Security rights, but we will allow the person who has been ruled incapable mentally to buy a gun. And let's make it clear that's what the rule did and confirmed and reaffirmed last week. Thank you, Mr. Chairman. I'll yield back.
Thank you. Mr. Smith, you're recognized.
Thank you, Mr. Chairman Johnson, Chairman Buchanan, for holding this hearing. I would like my first question to go to Ms. Licanfora. We're limited on time, so I would really like just yes or no answers, because I want to try to hit as many as possible. When the Social Security Administration assigns someone a representative payee, this means that the individual will no longer receive his or her Social Security payment directly. That means the payee will manage the benefits on the individual's behalf. Is that yes or no?
Yes.
Yes. Does having a representative payee assigned by the SSA also keep someone from writing a check?
No.
How about managing their own bank account?
No.
So to be clear, how about making decisions about their medical care and setting a doctor's appointment?
No.
So to be clear, having a representative payee only affects receipt of one's Social Security benefits?
Yes.
Thank you for clearing that up. Ms. Nichols, I have a question. Do you believe that laws prevent gun violence?
Yes.
Okay. Have you looked at the 20 last mass shootings in the country? The statistics of whether those were in gun-free zones or not? I take it you haven't.
Yeah, no.
I would encourage you, as someone who cares about, quote, gun violence, that you look that by far the supermajority of the mass shootings were in gun-free zones, saying that you are not allowed by law to have a gun. And numerous people lost their lives. So those are laws that basically created more gun violence. So it might be something you look at. One further question. This question is for Mr. Applebaum. My concern here is that if someone is giving a payee and they don't need one, SSA will unnecessarily infringe on their autonomy. On the other hand, if they don't have a payee and need one, they may not be able to manage their benefits effectively to address their needs. Dr. Applebaum, one of the issues that the Institute of Medicine explored is how to actually define financial capability. Can you talk a little bit about what it means to be financially capable and how this can be assessed?
Yes, I'd be happy to answer that. As you heard, SSA's definition of capability is somebody who has the ability to manage or direct the management of their benefits. But the committee broke that down, that rather vague formulation, into essentially three components. We think of people as having some basic financial knowledge. For example, if I give you a $5 bill for an item that costs $2.99, how much change I should receive in return. And financial judgment, which is to say the ability to assess the legitimacy, for example, of offers that might be too good to be true. And together those constitute the foundation blocks, knowledge and judgment of financial capability. But there's one more component that needs to be considered, and that is how people use their knowledge and apply their judgment in real-life situations. And that we call financial performance. For example, somebody who becomes incredibly anxious and unable to process information when they're on a checkout line may have all the information but lack the capability because they can't perform with that information. And conversely, somebody who in real-life situations has someone to help them make these decisions might do perfectly well even though they have some impairment in their judgment or knowledge.
Does the SSA's capability determination process do a good job at evaluating whether someone is capable of managing his or her benefits?
So unfortunately, we don't know the answer to that question in any objective sense. That is, SSA has not, as best we can determine, systematically evaluated the accuracy of their determination process, also one of our recommendations.
Thank you, Mr. Chairman.
Thank you. Mr. Kelly, you're recognized.
Thank you, Chairman, and thank you all for being here. Whenever you hear that somebody's incapable of doing this, how do you hear that? I know you're saying the model about people who can't pay their bills. I have a lot of friends who are very sharp, but they just don't pay their bills on time. So when it comes to these folks, what triggers that? Ms. Lockenford, maybe you can help with that, because I know a lot of these things. So who is it that makes the call to Social Security that says, hey, you know, my mom's lost it, and I think I should be getting it? How does it start? I'm really curious.
So essentially, we presume that all adults are capable,
Right.
first and foremost. One of the ways that the issue of incapability arises is when someone's going through the disability determination process and a state agency disability examiner is reviewing the medical evidence. That examiner may come across evidence that suggests that there could be a capability problem, and they will flag that for our field offices. Our field offices will then take the input from the disability examiner and couple that with lay evidence, which is that evidence of the real-world knowledge of financial oversight by people who know that person well. And the body of that evidence will shape the decision.
Okay, so, and I know you have legal evidence, medical evidence, and then lay evidence. Then the question becomes, that person that we're questioning their ability to determine, do we do a face-to-face with them to determine?
By and large, we do, although there are circumstances where we don't think it's appropriate to compel the person to come to an office because of their own personal circumstances. But by and large, we do try to do a face-to-face interview in all cases. We also take the statements of the individual themselves and anyone who knows them, who has working, daily, recent knowledge of the individual's ability to meet their daily needs, to pay their rent on time, to feed themselves, and to do all those things that we would expect.
Yeah, so I'm now, then the question would come, so these people that are doing the interviewing, their backgrounds, I mean, how do you find these folks to do these interviews? I mean, do they have the education to do it? Are they're so well trained? I look at this because when you start playing with people's income and determining whether they're capable or not capable, as I said earlier, I have a lot of friends who are very, very capable, but just don't pay any bill on time. And people would say, listen, that person's irresponsible. They don't know when to pay their bills, but you don't take their benefits from them. I'm really curious about this, and I think it seems to me that there's such a gray area. The definitions, I think Ms. Stone talked about documented determination. I mean, who documents, who determines, who defines, and does it vary from person to person? I think there's so much in there that would be flexible and up to the individual doing the interview. And did they have a good day before they got to the office?
I agree that it's a difficult job. The statute requires that the commissioner determine whether it's in the interest of an individual to have a payee, and that's the statutory construct. From there, we have so many beneficiaries, as you well know,
Yeah.
62 million people. The task at hand can't be done by just a few people, so we task our field offices, by and large, to examine all of these various pieces of evidence, and we try to provide very detailed, concrete questions to ask both the individual and anyone else who provides lay evidence. We have a particular form that goes to medical providers to elicit their input, and the totality of all that evidence helps the adjudicator to decide whether the person needs a payee.
Yeah. Now, just for all of you, if you can, because I think sometimes when we see a check that comes from the government, we assume that it was actually the government that supplied the revenue. Just to clear it up, where does the revenue come from for Social Security?
From the taxpayers.
And not just taxpayers, but it's actually wage taxes, right?
Yes.
Okay, so if we're looking for revenue and we're talking about budgets and budget cuts, and we have we don't have the rate of participation we need in the labor force. I know we're looking for money all the time, but I think I would go back to a healthy economy and a labor force that's actually working at full capacity, provides every single penny, not just, by the way, the person who is the employee, but also by the employer, right? It's a 6.2% matched by a 6.2% or 12.4% of every pay that goes to Social Security up to $118,500. So as we look to where we're going to find the money, I think it's easy to say, hey, look, we just have to devote more money. But I think it really is important to go back and find out, where does the revenue start? Where's the source of all this revenue? As opposed to saying we need to put more money into it, I'd like to find out, how can we make the actual revenue source healthier, that we can do this? And I think sometimes we get wrapped around the axle and all these things about the government does this, the government does that. The government doesn't do a damn thing on its own. It's all by hardworking American taxpayers. And in this case, every single penny comes from a gal or guy who gets up every day and goes to work and puts 6.2% of his or her paycheck matched by their employer with 6.2%. I think it's really incredibly important that we understand just whose back we're riding on. So I appreciate everything you're all doing. And I know it's complicated, but I worry about this. I have friends who are going through this process, and it worries me that somebody can determine whether they're capable or incapable, and then it's like, well, who was it that did that, and what was the determination based on? Chairman, I thank you very much, and thanks so much for being here. You guys do a great job. Thank you.
From Connecticut, but it was a remarkable comeback.
Thank you. Mr. Davis, you're recognized.
Thank you very much, Mr. Chairman, and I also want to thank all of our witnesses. I've found this discussion to be tremendously interesting as well as important. Commissioner, could you explain a little more in detail what kind of training or what it is that you really do for those who have to ultimately make the determination?
Sure. As I mentioned before, the population that we serve is vast, right? It's pretty much every American, and the number of beneficiaries we pay every month is 62 million people. So we've got to rely on our network of field office employees across the country to help us adjudicate these cases. What we do is provide all of those entry-level professionals with about 3 months of extensive training, 40 hours of which is specific to the rep payee process, and the adjudication of capability is part of that. And we provide ongoing training. As I mentioned, this upcoming April, we'll be doing mandatory training for all field office employees on the capability policy.
Thank you very much. Ms. Nichols, let me ask you, and I have a great deal of appreciation for the work that you and the organization that you're with does, especially given the fact that it was created not necessarily by government, but it was created by individuals who had a great interest in the issue. One of the things that strikes me is the issue of suicide. It appears that there are more suicide decisions that individuals make themselves, and one of the weapons or one of the means that they use is a gun. And there are other approaches to suicide that people also use, but it seems that those that they commit or do using a gun is more effective in terms of the person ultimately dying or simply not being here or being good. The determination that one is capable of handling or making use of, not making use of a gun, and suicide, I think we know to be kind of when the mood hits you, that there are times when people are impulsive and they make the decision. Would it not seem that there would be no use hardly at all for an individual with those conditions to have access to a gun? How would you respond to that?
I think the rule that that the Social Security Administration promulgated is very narrow, so that it does apply to only the people that would be at a higher risk of being in that kind of situation and making the wrong impulsive decision. You're exactly right in pointing out that that suicides are often decisions that are made very quickly. While the person is under duress, and when people don't have access to guns, the risk goes down significantly. When a person lives through a suicide attempt, they're 90% of the time they don't go on to die by suicide. So the reducing the gun during a particular time can have a tremendous effect at saving lives.
I know that there are people who express interest and concern about due process rights, just as individuals express concern about Second Amendment rights. And do you believe that due process rights are overwhelmingly important to the extent that we don't make the adjustments for individuals who are simply mentally impaired and unable to make rational decisions?
Due process is extremely important, yes.
Thank you very much, Mr. Chairman. I yield back.
Thank you. Ms. Wolarski, you're recognized.
Thank you, Mr. Chairman. Thank you to the panel for being here today. Dr. Applebaum, in your testimony, you mentioned that this SSA current evidence collection process does not provide clear instructions to guide SSA employees as they assess the reliability and/or quality of the evidence they receive. SSA also doesn't ask those providing evidence for information that might help employees in assessing the reliability. For instance, the medical evidence form doesn't ask how often a provider sees a beneficiary or if those interactions give the provider an adequate window into their financial capability. This concerns me because we're not just talking about assessing the fitness of a person to make decisions for themselves, we're also talking about a decision that affects their dignity. It's alarming to me that such a consequential decision could be arrived at without high-quality evidence that can be verified as relevant and factual, especially when it comes to vulnerable populations that could be targeted and probably are by bad actors. So, Dr. Applebaum, my question is, are you similarly concerned with this, and how can the SSA improve their own processes to address this problem? It really comes down to the issue of quality of evidence.
Thank you. Yes, I am concerned. More importantly, the committee was concerned, the committee that I chaired for the National Academies. But it is a process that can be improved. It can be improved in two ways. One is by providing structure to informants, whether those are physicians like me, whether they are lay people, family members, friends, other professionals, clergy, people who come into contact with the individual, as to what information they should be considering and providing to the agency. For example, does this person pay their bills regularly? Has this person ever missed a rent check? Who buys this person's groceries, and how adequate is their ability to supply themselves with food and clothing? These kinds of directives can improve the quality of the evidence that SSA obtains by focusing people on what's really relevant to a financial capability determination. The second thing that could be improved, that could be changed, is the information source could be specified, which is to say, for example, currently the form that physicians fill out asks for a judgment by the physicians, and in general terms, the basis for that judgment regarding financial capability. But the form doesn't ask where the physicians get the information from, nor how frequently they see the patient and how intense their relationship is. If we knew from each informant how often are you in contact with this person, and what is your judgment based on? Is it based on observation or third-party reports or review of records of somebody who you saw once a year ago but haven't seen since? That would improve SSA's ability to judge the quality of the evidence. And I would just add that my understanding is, although I haven't seen them yet, that SSA has taken steps towards specifying the information that they desire. It's not clear to me that they've done the second part of that yet.
So let me bounce over to you, Ms. Lackenfora. So given how important this is and the direct connection it has to the dignity of people, so has SSA walked through these suggestions, this model, or what are you doing to improve that quality of evidence?
Yes, I think Dr. Applebaum stated it correctly. We have fully implemented the recommendation that the committee made to create a more robust set of instructions for our offices who gather evidence. So, for example, the questions that he just posed about, do you pay your bills on time? And we have an entire list of those questions in our policy now so that we don't leave it up to field office adjudicators to think of them. We're actually giving them a script, so to speak, so that they are, in fact, collecting the appropriate evidence from lay parties. The second part we are in the process of working on, which is we have a special form that medical providers complete, and it asks them a host of questions about their assessment of an individual's ability to manage benefits. We are in the process of making that form more robust in some of the ways that the committee suggested.
And I just have a real quick follow-up question to something you were speaking earlier with Chairman Johnson. When you talk about kind of like accountability and transparency with SSA employees as they look in this large process that they're looking at, do you use these on-site contractors as third-party verification kind of folks to make sure that these the employees are following the regs and the changes that SSA is making? Do you use on-site contractors to kind of help look in and make sure that's happening?
No, the on-site contract that I was referring to is our monitoring contract. So that's the contract we use to go out and do site visits and look at the performance of payees to ensure that they are not, in fact, misusing or abusing the beneficiaries whom they serve. With respect to our own employees and the performance thereof, we have internal quality reviews in addition to, the report that we commissioned with the National Academy and our IG reviews. We have our own internal quality assessment to help us to track and measure the effectiveness and the compliance with our own policies.
I appreciate it. Mr. Chairman, I yield back. Thank you.
Mr. Anesi, you're recognized.
Thank you, Mr. Chairman, and I want to thank both you and Chairman Buchanan for holding this hearing. I want to thank the witnesses as well for their testimony. I apologize that I wasn't here for the entire hearing. I was actually at a budget discussion where we're talking about the sustainability of Social Security, so it's a whole other issue for another day and another time. But the GAO recently found that 62% of retirees above the age of 75 rely on Social Security for more than half of their household income. Additionally, Social Security benefits make up the largest component of household income for most retirees. It goes without saying that the ability for a retiree to properly manage their Social Security checks is critical to their retirement security. As someone who ran numerous businesses for 25 years, many of those, I was in the healthcare business and a nursing home business, I ran into many individuals who had Social Security and had management payees as well. So I'm interested in learning more about how the Social Security Administration field offices determine if a Social Security recipient should have a representative payee. So, Mrs. Lankenfor, which field office employees are making determinations for the representative payee program, and what are the qualifications to be hired for that position?
So by and large, it's the claims representatives who work across the country interacting with the public, taking retirement disability claims and the like. Those individuals are generally, college graduates, entry-level professionals. They do not have medical training, but they do undergo significant training to learn the Social Security programs, including the representative payee program.
So in an individual's life, there are clearly changes in medical condition, there are changes in life history, life habits. What role do the supervisors play in overseeing the capability of the determination process? I'm big in the process. I believe my success in the business world was about adhering to process. Sometimes I wish all of us in Washington would follow a process. We'd probably be better off. But what capability determining processes do they have to sign off on these decisions? Where are supervisors involved?
So there's so many decisions that are made, hundreds of them every day in field offices, that supervisors are not signing off on every decision. But as Ms. Stone said, one of the things that the IG recommended and that we are in the process of implementing that we think will get at the issue of ensuring both consistency and compliance with the policy are the systems changes that we're making to require those individuals to fully document and explain what evidence they used and how they adjudicated that evidence to make their determination. The problem that we have is that our IG, our own quality reviewers, pointed out, and rightfully so, that the documentation around those decisions is lacking, and that right now is job number one, to ensure that the documentation is done and that we're complying with policy.
Mrs. Stone, do you have any additional suggestions to improve the training process that SSA should consider?
I do not. Based on our work, I would not say that training was the main issue that we identified. It was more compliance with the existing policy that the agency had.
Thank you. I want to thank you again, all of you. It's important for Social Security Administration to continue to work to really improve representative payee program, and I look forward to further work on this important issue. I yield back my remaining.
Thank you. Today's hearing focused on how Social Security decides who needs help managing their benefits. And while Social Security has made some changes, there's still work to be done. The next hearing in this series will focus on who provides that help and how Social Security makes sure that they're doing a good job. Social Security's representative pay program is too important not to get it right, and I look forward to working with Social Security stakeholders and all of my colleagues to make changes if necessary. Thanks to our witnesses for their testimony. I thank you also to our members for being here. With that, the committee stands adjourned. Thank you to all of the witnesses for being here as well.
My two heroes.
Thank you, Mr. Johnson. Thank you, sir.
Thank you. Thank you for being here.
Thank you. Always good to see you.
Thanks for staying.
That's great. Well, I told the chairman, I think we gotta go to Plano, Texas. Because this is his last
So where?
term of Congress.